We are back with another video of Criminal Procedure Act, which you are going to write very soon in May. So trying to work with us will really help you. So today I will be dealing with question number 1. It says, discuss the jurisdiction in respect of offenses of the following courts: the Supreme Court of Appeal, the High Court, which are the divisions of the High Court. They want to say that the District Court, which is a magistrate court. We have a regional court, which is part of the magistrate court. Okay, in order to answer this question, you have to what we can say to restep back. Oh yeah, should I say that? So you must go to the ILW 1501 study guide. Do you remember? Firstly, you have to define what is jurisdiction. Here they said that the jurisdiction is the competency of the court to hear the matter and adjudicate. So competency of the court to hear the matter and adjudicate is called jurisdiction. So jurisdiction, there was a question here by Mr. Scotchbolt, which was answered by Mr. Comics. Mr. Comics said there are a lot of factors that determine a court jurisdiction. In criminal matters, the type of offense and the sentence determines court jurisdiction. But because today we're talking about the civil, so we are going to look at the type of offenses and the sentence to determine the court jurisdiction. So it means that now you know the factors that determines the court jurisdiction: type of offense and the sentence. So we have to deal with it in a way that you could know, even though we will answer both type of offense and sentence. So secondly, let's go and look at let me try to search here. Let me try to say, okay. Another thing that we must know before we go to answer the question is what we call judicial precedent. We have studied here in the ILW 1501 that the lower courts are bound by the decision of the higher courts. The lower courts are bound by the decision of the higher courts, and we call this judicial precedent. So now when we know about it, we have to go and look at the hierarchy of the court. It means that we have to go to look for a hierarchy of the court, right? Yes, here we have a hierarchy of the court. Let me search this. Yes, this diagram. I want this diagram. So in the hierarchy of the court, we have a constitutional court, we have the Supreme Court of Appeal, we have a High Court, we have a Magistrate Court, which is divided into district and regional. Here, in this question, they are asking about the Supreme Court of Appeal, the divisions of the High Court, and Magistrate Court. So now we are going to give. So when we talk about the Supreme Court of Appeal, you must know that in the Supreme Court of Appeal, they only appeal, or review. So they only appeal to the Supreme Court of Appeal. So if they appeal, it means that they can appeal any type of offense which is coming from the High Court. So any type of offense which is competent to be heard in High Court is competent to be appealed in the Supreme Court of Appeal. So this is what you must know generally. Okay, then it means that we are going to look in the lower courts and the high courts jurisdiction. Okay, let's start with those, then we'll go to the Supreme Court of Appeal. So we'll start with the jurisdiction. They said jurisdiction in respect of lower courts. Lower courts comprise district courts, e.g. magistrate court for a district and a regional court. Magistrate court for a region The jurisdiction of a district court or a regional court is limited in respect of the area within which the offense is committed, in respect of the type of offense which it may try, as well as in respect of the punishment which may be imposed. No magistrate court has jurisdiction to decide on the validity of a statutory provision. That's number one jurisdiction that you must know. Okay, jurisdiction in respect of offenses. A district court has a jurisdiction over all offenses except higher treason, murder, and rape, and compelled rape, as contemplated by Section 39 of the Magistrate Court Act 32 of 1944. A regional court has a jurisdiction over all offenses except higher treason. Section 89 of the Magistrate Court Act 32 of 1944. Note that the district court may therefore even try the serious offenses of terrorism, subversion, and sabotage. A regional court may also try the offenses of murder and rape. See Section 110A of the CPA in respect of the offenses committed by certain persons outside Republic. So now we have dealt with the lower courts. We have understood that my district cannot hear the case, can hear all the cases except with the rape, murder, treason, and compelled rape. And we hear that even the regional is still the same. They can hear all the offenses except higher treason. They can try serious cases of a rape, a murder, and those other cases that have been. So those were the things that you must write about the lower courts. Now let's go and check the high court. And then in the high courts, they said that the jurisdiction in respect of high courts is not discussed here. Higher courts have an original jurisdiction to try all cases, as well as appeal and review jurisdiction. So it means that the high courts, all the divisions of the high courts, can hear each and every type of offense. Since High Court can hear all the type of cases, it's very much important to supplement that it can hear the treason. And we must reflect on this study guide, which is the specific crime. You know this study guide, all of you are doing in Nissan. So only study guide for CRM. It's very much important when you read, you do not read to forget. Because if you read to forget, some of the cases you just find from some materials. So they say here they talk about terrorism and public violence. And they say that the most important common law crime against the state are higher treason and sedition. And these are the ones that are heard in the High Court. I'm talking about if you are, we are still answering that question, and we want a case that we can supplement that the treason can be heard in a High Court. The most important statutory offense is that of a terrorism in terms of a protection of constitutional democracy against terrorists and related activity which came blah 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 blah. And then they define such a thing, and then that is not important. The important is to look for the cases which I believe that we can find, and we have found the case. It said that in the case of SV Oka, and then they put the case. The accused, a Nigerian citizen but a permanent South African resident, was the leader of the militant group movement of the emancipation of the Niger Delta men. He masterminded and bankrolled 4 car bombings in Nigeria. The bombs killed 9 people, injured many others, and they caused extensive damage to property. Mr. Oka was in South Africa when he planned and executed some of the bombing. The Supreme Court of Appeal ruled that under Section 15, subsection 2 of the Terrorist Act, there was a close nexus between the terrorist acts committed or the accused and South Africa, and convicted Mr. Oka of terrorism. this was the Supreme Court of Appeal. It means that if it is a Supreme Court of Appeal, then the case was heard in the High Court. All right, since the district can't hear the treason. So it's another case that proves that a Supreme Court of Appeal and the High Court can actually hear the case of treason, which they have heard the case of the Oka. You must not forget those cases from other books. They are very much important. Now we have a final answered this question. We have learned that the Supreme Court of Appeal can hear the treason and all offenses that are appealed from the High Court, which is the divisions, and all divisions can hear all the types of cases, unless if there's a limitation based on such a division. You must state that in the examination. It's just that I'm not finding on your prescribed book, because mostly I don't use your prescribed book. The district courts, we heard that they cannot hear treason magistrate together with a regional. However, regional can try those other cases. So if you have written that, you'll be getting some 15 marks. Marks. So tomorrow when we do the video, we'll be talking about the question 2. Question 2, which says that in the criminal justice system, the prosecution can do what is legal permissible to set criminal proceedings in motion, such as determining the charges and the date and the venue of a trial. Discuss the phrase the prosecution as dominus litis. And then we have another question. It says that it's a basic principle of the law of criminal procedure in almost every civilized community that the trial of an accused must take place in his presence, and the verdict of the court and the sentence that is imposed must be pronounced in his presence. Critically evaluate this position in light of the constitutional and judicial interpretation. So these are the other questions that you must watch my video when I'm answering. I'm going to be answering question 2 and question 3 tomorrow, and you'll get the video later in the day. So make sure that you are following me when we try to answer these questions that may be in your examination. Good luck, guys. We will meet each other when I post another video.